Ladies and gentlemen of the committee, raise your hand if you do not have the handouts that have been provided. Okay. And if Ms. Brooks, if you can, if there's folks, if you have some extras, you want to make those available to folks that would like to see them, you can make those available as well to folks here. I think all the committee members have them that are present. So ladies and gentlemen, welcome to the House Committee on Science and Technology. Today we're meeting and continuing the conversation that we started back in May about the internet platforms and internet speech. Wanted to again welcome folks who might not have been to our May hearing. Our goal in this is to take a little bit deeper dive than sometimes we have the ability to do during the session, to look at the issue of internet platforms that are simply furnishing a platform for other folks to engage in speech versus the issue of publishing and promoting material themselves. This is an issue that's been with us for a number of years. It's gotten some attention the last couple of years. I think it's something that the public is interested in, and I think it's something that, because of the contours of the legal debate, we do well to take a deep dive and understand rather than act first and deliberate later. So there's a number of states that have acted. Some might say wisely, some might say unwisely, others might say wisely but hastily, and others there might be opinions in between. Our goal as Committee on Science and Technology, as you know, is to take advantage of the out of session time we have over the course of the interim, delve deeply into issues, understand issues, help frame issues so that can inform any efforts that might lead to legislation or not, as we would contemplate action next legislative session. So our goal is to, as we've always been, is to delve into hard issues, multidisciplinary issues that aren't as simple as a civil torts issue or civil rights issue or criminal law issue or a property rights issue or a antitrust issue. There's a lot of the issues we wrestle with, intellectual property, do touch these facets in many different and often complex ways. So our goal is to do our homework, and that's what this committee hearing today is intended to do. I'd like to thank our speakers. We've got a distinguished panel of speakers with us today to speak, and I appreciate the attention of committee members. Last hearing, the engagement was very strong, and I think anybody who was part of that can recognize this is a committee that talks about things. We have very strong discussion, bipartisan discussion from a variety of perspectives, sometimes from 4 or 5 perspectives. And I think that's important to, again, helping us move in the direction of what is sound policy, what's the right way for Georgians to move forward on the issues this committee addresses. Broadly speaking, I want to just address this issue of what's referred to as Section 230. For those who are new to this issue, what we're really wrestling with is, I think we can all agree that broadly the issue relates to internet platforms where there is a whole variety of speakers, promoters, providers, commercial agents that are involved in commerce, to speech, to promotion, to a whole number of things. And this idea has always been one that has to be managed with a very careful balance. And I think members of the committee recognize that. In 1996, when the act that we're really focusing on at the federal level was addressed, it dealt with this issue of obscenity, that even though in many cases obscenity is constitutionally protected speech, we wanted to create a circumstance where platforms could partner with others and take down what is otherwise objectionable material that maybe parents don't want their kids to see, to provide some protections for platforms by giving them legal protection if they're not the actual publisher of the content. If someone takes advantage of their platform, they post content, that the platform provider is not accountable for that content because they didn't publish it. It's published by somebody else. They're simply sort of a town square where conversation and speech and content can happen and be presented. When that's the posture that's taken by platforms, and they have those broad legal protections that are outlined in Section 230. The question in play is how involved in content management can platforms be and no longer become publishers or promoters of content and stay simply platforms? Where's the balance? How much content management outside of that which is criminal or that which is, clearly falls in the definition of lewd and licentious and otherwise, to what degree can that content be selectively posted, deplatformed, managed, and the platform provider still just be a platform versus kind of transition from being simply a platform for speech to being a publisher themselves, where they're really promoting some or allowing some to persist and taking others down. It's that issue of when are you simply a platform and when do you transition over and become a publisher, promoter, and a sponsor of content itself because of your careful and detailed involvement in that. It's not an easy question. We recognize the great businesses that have been forged over the last 2-3 decades, business platforms, places that people make their livelihood by using these platforms to promote their products and in some cases sell their products. So it does really become the town square in many ways. And as the town square, who can be kept out of the town square and under what circumstances? And if it's private entities that are making the decision as to who can be present in the town square commercially or from a speech perspective, at what point does that intense granular management of those activities cease to be simply a platform, but actually become sponsored activities where there's versus how do we strike the balance? It's something that our culture is wrestling with, and there's no simple answer. I don't think there's a single person here who truly understands the issue who would say it's a simple issue. So as such, we as states have interests that we have candidly a broader scope of responsibility as a state than even the limited enumerated powers of our federal government. So that's for those who are watching today who've perhaps not been part of this issue. That's the debate we're framing, and we want to have vigorous discussion around. And wanted to make sure that we're framing this and in a way that we, again, those that are not engaged in interstate commercial law and copyright and the issue of federal preemption versus state action on certain areas, antitrust law. If you're not an expert there, we want you to understand what the debate's about today. So what we're going to do is I'm going to recognize some speakers. I'd like them to identify where you're from, who you represent, what your perspective is. One thing that's great about our country is everyone's welcome to be here. Everyone's welcome to, we have a vigorous debate. And if you work for an organization and a trade association, that's who you work for, they have you rep them and rep their interest, and that's okay. We want the experts. We want people that represent some of the interests that are involved in this to speak vigorously and clearly, because your expertise and your interests are very much in play. So with that, what I'd like to do is I'd like to recognize our first speaker today is going to be Mr. Jim Halpert. Mr. Halpert, if you could approach the podium, tell us who you are, where you come from, and I'll give you an opportunity to be our first presenter today. As Mr. Halpert's approaching the podium, what I do want to do today is, I'm going to turn your table mic on. Could you make sure that table mic works?
I believe so.
I think it does. Good.
I'm going to make it be a little closer to me. So
Mr. Halpert, before you jump in and tell us who you are and who you represent, I do want to tell our committee members, I do want to keep this substantive today. There is, as you know, I like vigorous questions in my committees because those questions get at the issues. What I do want to do is I'm going to ask us to focus on the issues in play. I think it's relevant. Whether you're a journalist, whether you're a trade association person, whether you're an attorney, whether you're an academic, I think it's important to folks to know, where you come from, what your background is. But I would ask members to be thoughtful, probative on the issues themselves. Last time I let the committee go, there was what others might say some ad hominem attacks on people. We reined it in some, but let's focus on the issues. Let's ask the hard questions, and let's take advantage of the experts we have with us today. So, Mr. Halpert, you've got the floor.
Thank you so much, Mr. Chairman and members of the committee. And I appreciate that this is an issue that does have some resonance among internet users. And I'll try to explain why this is a lot more complicated than it would first appear as a question. And my name is Jim Halpert. Obviously, the character in the TV show The Office is actually named after me. My good friend created the show, and we hung out on the 4th of July, actually, which was great. But I have years of experience counseling clients both in the US and internationally on privacy, cybersecurity, and internet content management slash third-party liability issues related to content that's posted on platforms. And I started doing this in 1995 as a wet behind the ears lawyer. And I have helped to draft a lot of the federal laws that govern this sort of responsibility for content. For example, the Digital Millennium Copyright Act, which deals with online copyright infringement. As part of my very first assignment, I was assigned to review the amendments that became Section 230 at a time when the internet was just dawning and it was a very, very different sort of environment than we have now. I've counseled a major internet marketplace on developing its prohibited items policy, people selling kidneys and things like that online, which believe it or not, was an issue in the 90s. At least people said that they were going to do that, which was crazy, and they immediately banned it. I've advised that same marketplace regarding the European Union's rules, which were developed in 1998 to 2001, regarding what could be sold on platforms. And then I advised it when its Indian CEO was thrown into jail for coming into the police department to report the sale of a video clip taken by one high school senior in New Delhi of him and his girlfriend engaged in having sex. And he filmed it, sent it to a friend, and then that was posted online. This gives you an idea of the sorts of weird problems that come up. And when he went to report this problem, the Delhi police said, "Not so fast. We in India have a very strong rule regarding obscenity. We consider this obscene. You're going to jail," which prompted a diplomatic incident in 2004. I've advised an online news site that moderates user comments on for politeness and decency. Basically, they don't want users being rude to each other, on the content liability and content moderation laws in 15 countries around the world. And I can tell you that the standards globally are wildly different. If you were to go to the Middle East, you would see a completely different set of considerations and concerns. And it's very complicated. I also advise smaller internet sites. Even today, a lot of this work is now managed in-house regarding content management. And I understand a lot of the practical questions that content management raises. And I'm here as a lawyer. I went to Harvard Law School, this kind of stuff, but I'd like to have a practical discussion with you guys about what this really entails. In the course of counsel.
And Mr. Calvin, if you could, as we get going, so that this is a vigorous legal practice for you. You're a practicing attorney in the area. Are you representing yourself, your firm, or is there a client that you're representing here today?
I was counsel to NetChoice, or one of the counsel to NetChoice, in their lawsuit against challenging the Florida law, but I'm not testifying on behalf of a particular client today, although I did share the testimony with the NetChoice team.
Thank you.
Thank you for the question. I have seen a significant increase over the years in affirmative content moderation by internet sites that host user-generated content. And this is largely for competitive market-based reasons. Platforms want users to choose their site over others, and users want to visit sites where they know what they're going to get. And there is a variety of choices in the marketplace for users who want different things. We can argue about market share, but a lot of this is based on the popularity of the site. The increase in content moderation is designed to address a number of factors. Starting in the 1990s, business goals of creating a family-friendly or more courteous online community prompted the discussion boards, like if you think about Prodigy or CompuServe, for those of you who were early adopters of being online. And that was a concern because, people posted all sorts of weird off-topic things, were very rude to each other. There was widespread concern then about child pornography images in the early 2000s and a host of other really disgusting content being distributed online, and child predators and sex traffickers, frankly, attempting to groom or lure children online. Some of that is obvious as to what it's doing, but there's a lot of much subtler communications that are probably protected by the First Amendment, but law enforcement came to internet sites and said, look, we need you to do more. A little bit before that, actually, there was a lot of concern about jihadi sort of radical, violent movements recruiting Americans online and then recruiting in other parts of the world. And again, the US government came to these sites and said, look, you need to do your part basically in addressing this sort of problem. A lot of this, again, wasn't illegal, but it was, people sharing, for example, lies that the US government brought down the Twin Towers. I mean, they're terrible lies that were spread around the world. And it was very important to act against that. There also have been complaints against harassment, egregious privacy invasions like doxing, which is putting people's personal information online, which I think Mr. Szabo will speak to in greater detail, and real rudeness and vulgarity by users. If you go to some of these online fora that don't moderate, it's really not a very nice place and not a good experience, and users don't like that. Also, there are fraudsters and sites that are funded by quack medical cures, things like that, that actually pose some risk to consumers, at least of getting ripped off. And that's another area of real concerns. Also, hackers will sometimes post content that's designed to trick people into clicking on a link and downloading malware. But you have all sorts of people who take advantage of this means of communication to do pretty awful things. We also have seen hostile foreign governments engaging in online disinformation campaigns, trying to sow divisions in US society. Russia and Iran have been particularly aggressive in doing this. Some of you may have read in the 2016 election about an effort to get civil rights protesters and another group to converge on the same part of a town by announcing rallies for each group. Again, this was manufactured by Russian agents, but they were playing divisions online in a way designed to foment division and hate in the US. And then sadly, the COVID-19 pandemic has killed more Americans than both world wars combined. It's a terrible, terrible thing. And there is an enormous amount of disinformation that's being spread online in all sorts of different communities. I mean, I'll give you an example. I went to get a COVID vaccine in Prince George's County, Maryland, because it was the closest. DC had they'd basically given most of their vaccines to federal workers. And so there was a way to do that. And I went to get my vaccine, and on my way out, I just courteously asked the people at the checkout, hey, have you gotten your vaccine? It's safe. I hope that they're giving you that opportunity. And the response back from the guy behind the counter was no. And he cited a particular rapper and said he died of a COVID vaccine. In fact, that's not why he died. But that kind of misinformation is spreading in all sorts of communities around the country. And as more and more Americans have died of this, the online platforms felt that it was important, and they had health authorities come to them saying, look, you need to label information that is counter to scientific accepted scientific research as being inaccurate, or at least point them to a site where people can find the real facts about this. That was a major issue last year. And then in January, we had an unprecedented violent attack by US citizens against the US Capitol. And so a lot of this is fueled by information that is being spread that may not be accurate. And there are times when law enforcement will come to platforms and say, you need to do a better job because you're a very, very powerful forum for spreading ideas, and our country is coming apart a little bit on some of these issues. So this just gives you an idea of the many challenges in this area. Now, it's important to understand that internet platforms don't take positions on political or religious views expressed by their users. Um, they want to serve as many people as possible. They want to create an online experience that, as I said, is competitive and will attract users to their system. Their content moderation efforts are aimed at responding to very real threats online. This is difficult and unpleasant work that platforms spend a lot of resources on trying to get right. It's hard, and it's particularly challenging because of the huge volume and huge variety of posts every hour. And it involves saying no to someone who's posted content. So this isn't something that internet platforms relish doing, and they would generally prefer that a court make these determinations. But the sheer volume of posts every hour, millions of posts coming on, makes this impractical. Is this done perfectly? No, but it is something that it relies on algorithms, and given the volume, and continuing to refine those algorithms is an ongoing challenge. But the decisions here are highly contextual, so that having one set of rules that's very, very clear, and if you say this type of content is prohibited, this type of content is not, is hard, particularly because the bad actors are very persistent in trying to evade the rules and evade detection. I'll give you one example. Child predators, who are about as despicable a force online as one could possibly imagine, they use varying visual symbols to try to communicate with one another undetected. Now, if you or I look at them, we have no idea why there's a two of clubs or whatever it is, but that's a signal that they're sending to each other. So the content moderation has to adjust when law enforcement provides additional information on the modus operandi of these groups to address that kind of problem. Or they'll deliberately misspell words to evade detection. Well, that can be the same misspelling or a word that means something else as well. So the filter is going to capture both of those, very different intent, but may capture the use of that other misspelling in some other context if someone uses it as slang. To provide another example, foreign adversaries will often work through hijacking other people's accounts, so the account may be taken down, or setting up bot armies of fake accounts to spread misinformation. This is a very widely known Russian misinformation tactic. And these are dynamic, deceptive means to try to evade. As anybody's innovative, they're going to do that. I mean, I'll give you an example from the very first, one of the very first assignments I had as a lawyer in 1996. An absolutely disgusting spammer emailed a whole lot of people on the internet using the name of the McCormick Spice Company, but changing one letter in the spelling of McCormick, and but putting their actual email address at the bottom, advertising pornography of leering anorexic people. It was really just disgusting. And so what at the time, this was email, so it wasn't being posted online. What we had to do was to go to Visa and MasterCard and ask them, because people were actually being asked to pay for, to view more of this stuff. And there was some crazy group of people who found this of interest to them. We had to go to Visa and MasterCard, and they kindly agreed to cut off payment to this site. But there are all sorts of weird typo squatting and bizarre things that come up online. In this sort of environment, the idea there should be some sort of common carrier requirement that social media sites must take on all comers may sound appealing in theory, but it's really impractical. Do you really want an internet that is full of lawful but awful content that fits a particular type of description? It could be about religion, but denigrating religion. You can imagine, neo-Nazi political speech that is protected if you have protection of political speech. You can go right now to 8chan on the internet, and you can look if you want at totally unmoderated content, but that's not something I want my family ever to see. It's not something that I'm going to use because it's offensive and gross to a lot of people. There are people who like that, and they can go to 8chan and have that experience. But if you say no moderation of political or religious content, you're going to see more and more of these bad actors who frame their content as religious or political, add a little element of it, and then put it up online. Also, do you want an internet where plaintiff class action lawyers can shake down social media sites that try to make the sites more courteous or provide a better online experiences for their users? That's was an element of the Florida law that was just enjoined. I urge real caution about trying to regulate in this area for 3 reasons. This just gives you some background and some understanding about this. It's not as though the social media sites are saying, oh, we hate conservatives and we want to take down their content. They're managing a whole lot of content. Some of it on the left gets taken down, some of it on the right, probably more of it on the right now because of the COVID-19 and the online insurrection rumors that traveled around the internet. Well, the first reason why harmful content shouldn't be subject to this sort of restriction is that it's very fast moving. There are thousands and thousands of bad actors, and the social media sites need flexibility to deal with the weird, child predator changing symbols and the typo squatting, the people, drafting stuff in different sorts of ways. And if you have lawsuits and potential, the person who does this is going to be hauled into court, they're going to be a lot more reticent to do this over time. And because bad actors are attempting to evade and innovate around these security measures in a continual game of cat and mouse, requiring public disclosure of the details of how the algorithms work, for example, or the employee training manuals, actually helps the bad actors, be they pedophiles, jihadis, fraudsters, or any of the other lovely people I just described. It helps them to evade detection. And on the other hand, having a statement of what are the sorts of prohibited items is totally appropriate, or the sites, publish transparency reports, which I think Mr. Szabo will speak to shortly. But also, because these threats keep changing, it's very important to provide some flexibility to meet what's essentially this ongoing game of cat and mouse and evolving challenges. Who knows, we may see China starting to sow other sorts of problems here over time. And it's important to not to be prescriptive in restricting this, but to talk about goals and ends. In some cases, bad actors do frame their content as somehow political, and in some cases, partially political messages that include other types of content will be addressed by these countermeasures or captured by an algorithm. In some others, users will inadvertently post content that fits a pattern that algorithms detect as indicative of harmful content, even though it isn't in fact. And I think that's what's animating a lot of the concerns here. Although this occurs in a tiny, tiny percentage of cases, with the huge volume of postings that happen every minute, this error rate generates an appreciable number of cases where users who post content that's removed are upset or that are labeled. And I mean, it's happened to me, and I understand why that's frustrating. But by the same token, there's a lot more that is really appropriately managed. And the key thing is to understand is that this is not some ideological game. In fact, I believe that a gentleman from Breitbart is going to be speaking. Breitbart was included among the sort of favored news sites on Facebook. So the idea that Facebook is somehow trying to crush right-wing content just doesn't quite fit with the way that content has been prioritized. Facebook used to have a list of favored sites that were what I would call mainstream news organizations. And they got complaints from conservatives about that. Glenn Beck led a group, and Facebook agreed to change the range of sites that get promoted and to include Breitbart. So I don't think in the grand scheme, saying that this is a deliberate sort of conspiracy or effort to squelch voices of one particular political viewpoint is really in the main accurate. There's a big problem that persists of bad actors trying to get around this. The second, so that's the practical side to this. Now I'll put on my pointy-headed lawyer hat and talk about the First Amendment concerns. The First Amendment and the other legal challenges that I'll allude to pose real challenges to states legislating in this area. They're significant. They shouldn't be blithely dismissed. And I'm afraid at the last hearing, the Heartland Institute did. Now, they testified on before on May 24th, a few days later, applauded by the Heartland Institute. Florida passed a social media anti-content moderation law. And in the Net Choice v. Moody case that my firm was counsel in, it was decided on June 30th, that Florida law was enjoined by a federal court in Tallahassee. And the decision is, I think, instructive, and I think it's important to understand that internet and social media and e-commerce sites have not only property interests, which Mr. Chairman, you described in I thought, a very clear way and a compelling way at the last hearing, but they also have their own First Amendment rights as editors, basically. And the state would be telling them that they need to carry content that the state decides that it wants to have be in the public domain or publicly available. And that's a form of compelled speech. So the First Amendment paradigm is not just property rights versus First Amendment rights. It's actually First Amendment rights versus user rights. And I'll describe for a second how those and there is also a property interest and the ability as a general background rule, if you operate private property to decide, okay, I don't want this person coming in and making that mess, saying this or doing that, that's counter to my values or counter to what will make my business prosper. But this is also a First Amendment issue. This is the First Amendment rights of the sites to create communities that reflect either the values they agree with or furnishing their users with communities that they think their user base wants to return to in order to compete in the marketplace. Now, the Heartland Institute, which told you at the last hearing that the states clearly have authority to legislate, lobbied for and issued a press release on May 24th praising this Florida law.
Let me say this, Mr. Alpert, we're not, last hearing, we invited a whole suite of folks to come.
And I don't mean to criticize you at all, but I'm trying to correct the record.
Understand, but the presence of an organization in our last hearing, that's not sponsored content.
Oh, I totally understand.
There was no affirmation of their organization last hearing. It was a matter of, they were the coalition of the willing who would come and talk to us. There are many groups who have folks sitting in this room today that would not come last time. They wanted to sit back and let other people talk. So I'm thankful they came. As we said very clearly before, we're not, this is not a Florida, Texas, what may or may not have happened there is interesting to us in as much as it's another state. It's instructive to perhaps how not to move or how to move. It's certainly, I think, helpful for us to understand those things. But let's let's talk about the facts as
Oh,
opposed to
no,
as
I
opposed to
will.
the actors who were promoting.
Yeah, no, I
otherwise.
just wanted to correct the record from the last hearing that this is easy. That was my simple point, not to criticize their being invited. I think it's great to have lots of different views, and I'm pleased that this panel has a diversity of views as well. But all I'm saying is this is very complicated. They were sort of blithe, and they were also blithe in calling these entities cartels, which is inaccurate. Mr. Chairman, you corrected that. They mentioned that 33 states are considering legislation. Well, the only state that's actually legislated in this area is Florida, and that's been struck down, which gives you an idea of how hard this is. There's a different approach in California that may or may not move, but I think it's not going to move this year. But this is hard. It's complicated, and I appreciate the thought that's gone into Mr. Chairman, in holding these hearings and inviting a lot of different speakers. Here's what the federal district court in Tallahassee ruled, and this will be appealed to the 11th Circuit. I don't think the result is going to change on appeal. Probably the appeal will be ruled on, sometime early next year, I would think, or middle of next year. But they said that social media sites do have First Amendment rights because part of what they do, not all of what they do, is expressive, to edit and curate content on their systems in somewhat the way that news organizations do, not exactly the same, but the First Amendment interests are present here. And this changes, pretty fundamentally that paradigm discussed at the last hearing. What they saw was the state infringing on the First Amendment rights of social media sites by imposing content-based restrictions on editorial decisions, and simply saying that that you should not moderate political content or religious content is a content-based restriction. And that's part of why this is, even though we want to protect religious expression and political expression, that is very, very likely, in all likelihood, a content-based restriction. So drawing that line doesn't solve the problem here. Heading in more of a transparency direction may raise different and easier issues. I described, providing the training manual is going to help people to work around the efforts, and the details on the algorithms are the same sort of thing. But the other thing to understand is that as a constitutional matter, the government has limited recourse to curb the speech of internet speakers, and but that doesn't apply to the First Amendment constitutional rights of private speakers against the platform, the internet, social media business, because there isn't state action, which is required for the First Amendment to apply. If, pick your social media site that you're angry at, they decide to remove content. That's not state action. The state is, you could maybe argue that with regard to the jihadi content or something, if law enforcement came to them, there was a specific request, but most of this is not about that at all. And so the state tried to get around this principle in the case by arguing that they cited two U.S. Supreme Court cases that had ruled that speakers could get access to private property in order to speak. One was a military recruitment case during the Gulf War, where universities tried to bar the military from going onto campuses because they objected in, 2006 or something to the ongoing conduct of the war in Iraq. That case, Rumsfeld versus Fair, was one case. Another was a shopping center case called Pruneyard, where union organizers were allowed to enter a shopping center. That was a 1980 case. The district court looked at both those cases, which the law firm representing the state tried to lean on very heavily, and said that both these cases were off point because in neither case was the university or the shopping center. Sorry, my phone is pinging. We'll get that off. In neither case was the university or the shopping center engaged in any sort of expressive activity. and there was no question about a message being confused of, approval or anything like that. But they found that the social media sites are creating a sort of community. Another example was the Etsy, the product sale, sort of craft sale company. They were actually covered by the Florida law, and they said, look, we have a certain type of craft user, and really our users do not, we want to have a respectful community. We don't want people selling Nazi symbols on our site, or we don't want to have, other sorts of, and that's quintessentially a First Amendment interest in creating this community designed to appeal to and attract different users. So the court also ruled, and I think Mr. Szabo may address this, that the Florida content moderation restrictions, most of them were preempted by Section 230 under the otherwise lawful provision that was discussed at length at the last hearing. And I won't go into that. But this is to say that there really are First Amendment issues here, even though these sites are open to lots of users. And there's also the way that the site is presented and framed. There are a whole bunch of elements that are expressive here. And so anything that you do in this area, I think really should be considered carefully in relation to the First Amendment, because you don't want to pass something that passes, then gets enjoined by that, that sort of puts people who want the legislation, gets them disappointed. So I urge you to think about that quite carefully. The other thing I'd mention finally is that states adopting differing or worse, conflicting restrictions on social media content moderation can create real hurdles to protecting users. Content is available nationwide, so it's not just as though what's in Georgia that's posted by Georgia will also be available to people in California or anywhere else in the country. And because it's available widely, the Dormant Commerce Clause, which is a restriction on states reaching out of their state borders and has been cited by courts striking down a number of state internet content regulation laws, is really implicated. But also, you don't want to have, if you think about what is acceptable in Georgia and California in terms of content moderation, and particularly even the AG's offices are not going to agree about that sort of question. And getting that sort of requirement passing in different states becomes difficult. A certain amount of transparency, I think, is probably qualitatively different. But again, specifics as to how that disclosure is made get very difficult if you have different requirements in different states. So while absolutely it's the province of states to protect their users, and you can look at Congress in any number of areas and say they're really, really slow and we need to act, I'm here to explain why it's important to be cautious. And Mr. Chairman, I appreciate your thoughtful approach here, and hope that this presentation was useful to members of the committee as you look at what I think is an important question, but a deceptively complicated and difficult one. Thank you.
Super. Again, I'm going to take I'll take 4 questions here. Your presentation was a little longer. We're cutting into Mr. Szabo's time here as we take questions, but that's, we'll be able to kind of handle that appropriately. So if there are questions, go ahead and push your buttons. Chair is going to recognize Representative Gilligan for a question.
Hi, thank you so much for being here today. And just to make sure I understand, because I don't have your bio in front of me, but you helped to draft the U.S. Code 230. Is that what I understood?
I reviewed it before.
You reviewed it.
Yeah,
okay.
yeah.
All right, great. So I just wanted to make sure I understand everything. Like I said, I don't have your bio in front of me. I do
Sure.
apologize to all of our speakers today. I don't have that information. So thank you for coming. And I just had a couple of things that I personally am very concerned about, and I want to help, because I do have a constituent who during the election cycle of November posted a video. The video was of the Camden County elections officials who were showing the Dominion machines and how to use those Dominion machines and how they can be misused.
Mm-hmm.
He was immediately taken off the Facebook platform. Now, this gentleman is an entrepreneur. He had 3 different businesses that he conducted through his Facebook marketplace. When he was shut down, it wasn't just him, it was all of his businesses that were also effectively removed. And he has no recourse. He got immediately a notice that he was shut down, permanently banned.
When did he receive that? I don't represent Facebook, but I can certainly. Take
I will
back.
have to go back and find out. Like I said, this is the swirl of everything that was going on back in November, December, January. It was somewhere in that time frame. I will have to get that to you. But he had no recourse. So he jumped over to Parler, and as we know, Parler was deplatformed. So he had no way to get his social marketing restored quickly.
Mm-hmm.
So what do I, as his state representative, do to protect his livelihood that was immediately banned with no recourse because it was permanently banned?
Well, first of all, I'd love to see the details of this, and I acknowledge that this is a difficult question. I think the right thing to do in this situation is to raise this as you've done. And I will make sure, again, if you could please send me through Ms. Brooks the details. I certainly, this is not an effort where people are relishing taking somebody's business offline. And if you could please share that, I will certainly take it back. And in the end of the day, there was, I don't know, again, I'd like to know the date in which this happened. There was a defamatory campaign. I mean, there are lawsuits being filed, and Dominion was upset about all that sort of stuff. So I don't really understand the details of it,
Right.
but certainly there should be a hearing and an appeal on this question, and I'll make sure that the Facebook folks, again, who are not my client, I didn't advise them, but they should respond to this.
And one more follow-up, if I may.
And I would say, but I'm going to recognize the board's starting to line up. I would say this, just the urgency of the issue. I've enjoyed a number of meals since January 1st of 2021. I've thankfully had the opportunity to feed my family for the last 6 months. When people lose their livelihood.
Oh, I completely understand.
It's easy to sort of externalize that and say, well, you know what, this is a gig, this is the gig business for him. It's sort of a side thing, or he should, it's easy to kind of, as legislators to sort of make that an abstraction. But just as we do in our judiciary committees, we're talking about people who are talking about their livelihoods, people. If they do act A, B, and C, meet these elements, they're going to go to jail. Then they're going to have to try to get their way out of it. These are clear and present issues. At some level, there is a sort of this is just big companies, big titans battling each other. It's the Steve Jobs empire versus the Mark Zuckerberg empire.
Yeah,
That's not really. I think our interest as a state is there are direct individual property interests that are directly being impacted.
Yeah.
So I just appreciate your sensitivity to that.
Absolutely. No, and I'm very sensitive.
And everybody on this committee has constituents that feel things at that very personal level.
Well, and I will tell you that there are even how to manage a search algorithm. For example, there are entities that sell search engine optimization services.
Okay.
This is hard, but it's hard in the context of hundreds of millions of bits of content that get posted. And it's certainly true, as I think Mr. Szabo will describe as well, that if the state wants to create an online public forum for anybody to talk about what's going on in the state, it's absolutely free to do that. And there will be a lot of people who are interested in having that discussion.
So one more quick question. I need to recognize somebody else.
And just to give you, thank you for the follow-up. So I, like many of my colleagues here, have taken the oath not only to the Georgia Constitution, but to the U.S. Constitution and many of my military veteran friends here to protect and defend up to our lives the U.S. Constitution. Therefore, we take that First Amendment right incredibly seriously. And I wonder, at what point do we go from flagging content, removing content, and just censoring speech that we don't like? Because even the ACLU has often gone out saying that the language that we must protect is the language that is unpopular. That's what we must be protecting. So I want to know, at what point are we flagging content just because we oppose the speech?
Well, and I don't believe, again, I'm not counseling most of the platforms that you guys are focused on here, but I believe that is not the thrust of even what the sites are about. This is mostly algorithms that are trying to screen for people evading the system. So stuff gets flagged by an algorithm. Then there's, in volume, some of it will happen in real time if there's a huge, like if there's been an attack on the Capitol or there's a vaccine stuff. So there just are times when some of these things will happen, again, because of, I'm talking about a tiny error rate, but the error rate is nonetheless of concern. So the question really is what to do about those error rates, and is there a system of appeal and an accountability, and is the response complete and total my hunch is the deplatforming, if it happened, was not posting one little video. It's probably a whole bunch of other things, but I don't know that, and I will go back and check. And I'm not here to say that this was inappropriate, but it merits a very detailed response.
So, Mr. Halpert, I'm hearing you say there's a range of responses from flagging, hey, this may be objectionable content, to removing, to across the board deplatform. There is a range of responses here. It's
right.
So the idea of someone being completely deplatformed is a first step. There's the question, maybe flagging as an intermediate.
Right.
And I just say that for committee members.
Absolutely.
With that, Chair recognizes Representative Dreyer for a question.
Thank you, Mr. Chair. And I do want to talk about the First Amendment. I just want to kind of boil it down really clearly. First Amendment applies to state government action. So it does not apply to private businesses. But if we were to pass something that tried to tell private businesses what they must publish, then we would actually be running afoul of the First Amendment.
There's a real risk of that,
right?
Yeah, to compel speech is a big that's considered a major infringement of the First Amendment. Yes.
So I would be at risk of violating my oath to uphold the U.S. Constitution if I try to regulate a private business and make them publish certain things.
Right. Whereas you could pass a law saying, here's the Georgia Public Forum. The state can create that for a robust discussion, and the state is also restricted in what it can, there'll be people who come on and use swear words or whatever. But the state you can always create more speech. It's saying to somebody they have to, either they can't publish something or they have to say something. The compelled speech concern that's the one that here is a real issue.
We could even create a marketplace for businesses as a state, couldn't we?
Certainly.
Yeah. Thank you. Thank you, Mr. Chair.
Thank you, Mr. Chair.
Chair recognizes Representative Oliver.
What year was 230 passed?
It was 1996.
And since 1996, have there been any state statutes passed that gave more protections to the platforms than 230 did? 230 seems to be a comprehensive protection legislation for your clients. Is that a fair statement?
It's not a fair statement in the sense that it's not for my clients. It's for anybody who sets up what's called an interactive computer service. It's basically a website.
That's fair. So there is no other state statutes that has changed these protections.
They
that's
haven't
been
changed them. Some have
upheld.
replicated them, but they haven't changed them.
And Florida is the first effort that's been passed. Texas has not passed yet.
It's not passed
So
yet.
in the first effort to sort of amend these protections in 230 has been struck down within the last 2 weeks.
Last 3 weeks, yes.
So your
2
platform
weeks.
folks are in good shape. There's nothing they need from the law. Is that correct? This protects them. 230 protects them.
I wouldn't quite say that, in the sense that what they're doing is they're competing in a marketplace, and they want to provide good experiences and to be competitive. So that's really their driver, rather than additional, they're not seeking to change the law. The law is what it is, but those are constraints. And if you have real angry people who are, have been harmed by a platform, or say they've been harmed by a platform, that's not a good thing either, just to understand. This is not about being judge and jury. They don't want to be judge and jury at all.
I know they don't,
Yeah.
because judge and jury might make them more liable. So I would agree with the chair that this is an incredibly complicated area, but I think your industry is in good shape. None of these activities are impeding on you yet.
At this
Political
point,
activities in Florida example is one example.
well, I think you always want to provide better service.
You're doing a good job.
Well, thank you for that, I guess. But
You're recognized. Representative McLeod for a question.
Hear me?
Yes.
Thank you, Mr. Alpert, for being here.
thank you.
So my daughter's 34 years old now, but back in the 90s, yes, the internet had unfeathered ability, right? And bullying, child pornography, misinformation was all part of it. And I think what you said through your testimony, and I took notes, is that was the social media platforms were approached by law enforcement as well as health officials to get some more guidelines to protect the user, right? And I think one of my crust of your presentation was that this platform is being utilized quite heavily, but at the same time, we do not want to have issues with where we're endangering other people. And as an elected official, we do take oath to protect and serve our constituents, both state and at the federal level. But one of the things I'm very concerned, we have a big saying about business in the state of Georgia. It's the number one place to do business. But I guess only conservatives have an issue when regulations or some controls are put in place. And I think that's a problem, because I don't think it affects conservative more than it affects people that are Democratic voters. It's a platform, but it's also a place where we do see a lot of misinformation and dangerous activities that can go on on those platforms.
Yeah, and it's a game of cat and mouse, as I said. And thank you, Representative McLeod. Appreciate it.
Chair recognizes Representative Earhart.
Albert, how are Pam and the kids? Pam Beasley and the kids?
Yes, well, my
sorry.
wife's name is actually Karen.
Oh, it is okay. I'm referring to, I guess, the Hollywood version of your Jim Halpert.
Yeah, he's doing. That guy is doing very well.
He's doing very well. He's doing great. I appreciate you being here today. A couple of quick questions, if I may. You indicated earlier the sort of this increase in the practice of moderation, going in and moderating people's speech on social media platforms has increased greatly, and that is generally in response to market concerns. That's
Right.
what you indicated to me.
Yeah.
Is that your contention, that this increase in sort of moderation of speech on social media platforms is simply to keep users happy, or to keep them from leaving those? I think you said they don't want their users to leave.
Yeah, what's overall overall important to create a family-friendly sort of atmosphere, for example, and that motivates a lot of this. If users do, generally speaking, again, I'm talking about the largest platforms, most Americans do not want to see people threatening each other, getting into really loud. It's like a bar fight. You just don't want to have that experience online. So
Right.
that's a lot of what drives, and the internet does push in that direction. I think just people sitting at home in front of their screen tend to get angrier. But I think that's a lot of the concern. You don't want to see snuff films. There's all sorts of other stuff that people can post just to get a rise out of other users, and it turns everybody else off. I think that's really the concern.
And I know that there has been a bit of an exodus of followers from, let's say, Facebook, for example, in recent years. My understanding, though, and most of the reading that I've done, is that's been related for, let's say, privacy concerns as related to to the platform. Not so much that they have been necessarily offended. There's not been a mass exodus of folks leaving Facebook because they've been offended by some sort of content.
I think again, I don't represent Facebook, so I really can't speak to Facebook specifically, but I'm not sure that there's been a real exodus. If you look at the popularity of Facebook and Google,
Right.
over
I've read somewhere
privacy.
like 15 million. They lost about 15 million customers between 2017 and 2019? There'd been a bit of an exodus.
I'm not sure. I really don't know.
You indicated they don't want to lose their users. Where, if you're talking about family-friendly content, broad-reaching, where would those people go? In other words, I guess what I'm trying to understand is if you're saying that they're making these moderation decisions because they don't want to lose users, where is it that they're afraid that these losers are going to go? I was wondering, what is another platform? Let's
well,
just
for
say-
example, Facebook and Twitter compete. There are Parler as a competitor. There are a bunch of other places where users go.
Of course,
to
Twitter
communicate.
is an entirely different type of platform than Facebook.
But
So I guess what I'm
functionally,
trying to
it's pretty-
understand is
it's pretty
what-
similar.
What is the
in terms of
competition for Facebook in the market? What would be an equivalent social media platform that is both family friendly, right, and broad reaching to the extent that Facebook is? What is its comparable competitor?
It's
That
comparable.
they could be afraid they'd be losing these customers.
Oh, its comparable competitor is people switching to other fora. I mean, even you can have discussions in Parler, you can have discussions on Twitter,
Right.
Instagram.
But there's
a
really
bunch of
nothing that
different-
exists on the extent and the breadth and of Facebook on that level.
But
There's nothing
I think
that
that's
has even comes close to touching the market share of Facebook.
So Representative Eric, you're making the point that there's not a whole variety of options and that Facebook's, okay, so I mean, we do have time constraints. I just
Yeah,
wanna make sure
absolutely.
We're framing that. So what I'm hearing you say is there's not this wide variety of equal options, and and particularly with consolidation of some companies buying others, that's been an issue. I know there's been some antitrust conversations happening at the federal level about this that's maybe outside of our scope.
Yeah, I think that's right.
But I really appreciate your time. I'm going to ask one more question, then I'm going to recognize Mr. Szabo. You talked about the platforms do have First Amendment rights to curate and sort of manage. And then there's this issue that, I mean, you drew the analogy of it's analogous to a news source, maybe not an editorial page, but sort of a news source. Where does the line drawn? As you recognize this First Amendment interest of a platform, not a publisher. You're not promulgating, you're not promoting, you're not creating content, but yet you're still expressing a First Amendment right. And as an entity, there's a speech right there. And there is this sense of managing as a news source, but yet you broadly enjoy this blanket immunity from responsibility, because you're not a news source, because you're not a content creator, because you're not a publisher, you're simply a forum where other folks express their speech. Where's that line drawn?
Well, what's really interesting, I think it's a great question, Mr. Chairman. In fact, even common carriers have First Amendment rights. And so the answer, or the Supreme Court has interpreted the First Amendment really, really broadly. One can quarrel with it, but that's where it's going. And for example, Justice Kavanaugh in the Turner case, actually involving a company based here, ruled that common carriers, or he expressed the view that common carriers also have First Amendment rights. There's also a case called Pacific Gas and Electric, where they were compelled to put an insert into their envelopes. They were a common carrier monopoly that they disagreed with. And the Supreme Court in 1984 held that they couldn't be compelled to say, it was on some sort of consumer issue that they disagreed with. So I think the answer is it's very, very broad, and it's also unclear. So this is a very challenging area from the perspective that you're approaching it. And again, I'm not here to say what the law should be, just what it is right now. It's
Because I think you would agree that, just as this issue has been raised, that the First Amendment protects one from government. There are, fundamental freedom interests that are really adjudicated through the private delivery of services. That's why we have public accommodations laws and those. When does something become a public accommodation? It's not the government that's furnishing a job to somebody, but yet there are regulations by which you can and cannot make certain distinctions about hiring practices. You can't make distinctions about who may or may not stay in your hotel based on certain criteria, because the relationship was not between government and someone staying in a hotel. It was between a private hotel owner and a person who had a right to stay in a hotel in 1964 and having a place to stay. So government got involved and said, you know what, you can't make distinctions based on someone's faith or someone's skin color and those kinds of things. And so because they're fundamental rights people have to enjoy the ability to live their lives. There are contexts in which, in the employment setting, for example, you can't make distinctions based on those protected classes in an employment context. There's no government actor in the middle of that. It's a private employer and an individual. But we look at these and say, in certain settings, in a public accommodation setting, whether it's a hotel or a lunch counter, in an employment setting, there's such an important interest of the individual to be able to have a livelihood, to be able to travel and live their lives. That the government does say, wait a minute, in this private on private interaction, there are interests that are in play here. And that's where I think we struggle. We're going to recognize Mr. Zaba, and perhaps he can address this. I'm going to kind of put a bow on the discussions we've had here by saying, I think it's insufficient for us to sit back. I'm just speaking as a member of the committee here, not speaking in my role as chair. I have my committee member hat on. There is an interest between private parties that if the forum by which, if the town square, as it were, where I earn my living through an online business is moderated in a private setting, if people lose their ability to have their livelihood because they can't get into this marketplace, if they lose their ability to speak because speech is really managed, ideally in a very innovative private context, managed by private delivery system. If my ability to host a website is in a private web service platform, there are interests to my friend Representative Dreyer's question. It's not purely a government on individual. These rights of free citizens are being played out and managed in a private environment, and that's how we want it. But there are rules of fair play that have been invoked in other settings to make sure that people can earn a living in a marketplace. They can enjoy public accommodations. They can not have arbitrary application of, well, we're not going to employ you here because we don't like this or that, this characteristic, or your belief about this. That setting plays out and has played out for generations in a private circumstance. And that's where I think there's concerns from a governmental perspective that what is the basis in which the delivery, online speech, online commerce can happen. That's the interest we have and the concern we have. I'll let you close on that, and we need to recognize Mr.
Well, first of all, the Title VII of the Federal Civil Rights Act, which is passed due to the efforts of Dr. King and many other brave Americans who struggled for that, doesn't define the internet. The internet didn't exist at the time. I guess Congress could make some decision about that, but again, those are very specific categories of discrimination, not a sort of general right to say whatever you want necessarily in that area. And so it's a somewhat different frame. But if you,
but I think you agree. I think you'd agree with me. The manufacturing plant of the 1950s and the online commerce of the 2020s, if it's the place where all folks should have equal access to earn a livelihood, are not fundamentally different. It's an employment setting. It's a platform. The internet access to engage in speech and other public accommodations of the days of the past are still there's a publicness to that, and there shouldn't be the distinction. Just as we said, and there's just as it's pernicious to everybody in this room to suggest that someone that runs a lunch counter can say you can't sit at this counter because of what you believe, to say that you can't be on my online platform because of what you believe. It's both a private delivered service, and the expression of basic rights are fulfilled and effectuated there. Just as property owners had property interests, individuals had liberty interest to be able to eat in a restaurant or stay in a hotel. We talked about that.
Right. But if there's,
so is an online platform fundamentally different, or are those same liberty interests? Does there need to be a recognition on platforms of an individual's liberty interest there, even though they're otherwise a private business?
well, I believe the question about being able to earn a livelihood if you're not engaged in other sorts of behaviors, if you're selling illegal drugs or whatever it is, that's a problem. But I also think about it a little bit more like, consider a mall or a place where street vendors can set up in the business context. If you're a street vendor who is, raising the middle finger at and yelling at or harassing other vendors, you're asked to leave. And the marketplace can make some distinctions. Also, if you are, spreading foreign propaganda or whatever, that may not be too popular with the people there. If you're, starting bar fights, that you get thrown out of the bar. So I think it's important to put this in context. I do agree with you, particularly Representative, your example of someone who loses their livelihood. That's a different category of sort of problem. And there may be some, sort of almost like consumer protection type of idea that, hey, if you're a small seller in some environment, you do have some sort of, if you can curb you stop waving the middle finger at or spreading, defamatory lies about somebody else, then you should be able to stay there. You do need to stop doing the other sort of conduct, though. At the same time, you don't have a right to sit on someone else's property and say, horrible defamatory things about somebody else in the middle of a national, sort of crisis. I mean, there are some limits to even the business owner interest. Again, I don't know the facts that you're describing. I really want to get more information, and I will reach out and get back to you.
Mr. Hubbard, I appreciate your being with us today.
Thank you all for the thoughtful questions, and thank you for having the hearing. And I'm sorry to take up so much time.
Chair, I'd like to recognize Mr. Carl Szabo. Thank you. Mr. Szabo, welcome. I'm going to ask you, I know we had in the interest of time, I have different perspectives on this. If you could make your presentation in 10 minutes, we'll take a couple questions. I'd intended to limit that to 4. I'll let a few more people talk there, but welcome. Tell us who you're with, who you represent, and the floor is yours.
Thank you, Mr. Chairman, members of the committee. My name is Carl Szabo. I am Vice President and General Counsel of NetChoice. I'm also an adjunct professor of internet law at the George Mason Antonin Scalia Law School. I'm also conservative. I'm an originalist. And that's kind of why I feel so strongly about some of the things that we do see online that do raise concerns for me as a conservative when I see people being removed, people being quote unquote deplatformed or blackballed or whatever we want to call it today. But then the other side of me, the originalist, the conservative side says, but that flies in the face of the notion that private businesses can be the arbiters of what is best for their users and their advertisers. If we want to support decisions like Hobby Lobby, Masterpiece Cakes, or Citizens United, which are centered around the principle that private businesses can decide what's best for their users and their customers, then how are we able to just abandon those values when they seem to not work, quote unquote, in our favor? And one of the challenges when it comes to issues of conservative bias or something like that is the echo chamber, right? So a lot of times you see conservatives saying, oh my gosh, I know of people, constituents that were removed, but that's kind of an echo chamber. So you only typically hear from people in your chamber. You don't necessarily hear what's going on to people who are not necessarily of your political affiliation. So my wife's a child therapist, and she explained to me that trying to disprove a negative or trying to tell somebody their feelings are wrong is not accurate, and I'm not going to try to do that. Of course, having said that, famous last words, I will give you a couple quick stats. PragerU, very popular conservative YouTuber. They have filed numerous lawsuits against YouTube for being put in what's called restricted mode. Now, restricted mode means you are not removed. It just means essentially it's like the family mode, right? It's the safe search mode. So restricted mode basically moves you into that category. About 12% of their videos have been put into this restricted mode, and 12%, that's a lot. And so we dug a little bit deeper on some numbers, and we said, okay, what's happening on the other side of the aisle? Young Turks. Young Turks is a very left group on YouTube. 71% of their videos have been restricted. 71% to Prager's 12. Daily Show, we're all pretty familiar with that one. 54% restricted. Democracy Now, also left-leaning, 46%. History Channel is actually twice as restricted as PragerU, 24% for History Channel. And why is that? Why is that? Well, maybe it's something they're doing a presentation on the Holocaust. Now, I'm Jewish. Holocaust is something that I want to talk to my children about. I don't want my son doing some school report and coming across, images of Auschwitz or similar. That's a conversation I want to have with my child. You could say something similar for the issue of abortion. That's something that you want to have a conversation with your child. So that's why things end up in restricted modes. It's not necessarily on the basis of political ideology. It's more based on the underlying content. One of the other things that we talked about is kind of restrictions on speech. Now, one of the biggest challenges when it comes to speech is defining what speech is. So let's presume we could wave a magic wand and put Section 230 to the side for the moment. We wave a magic wand and we are going to write the most perfect law that says you can say whatever you want except for these following categories. And I'm going to just pick a couple because they do come from Section 230. We'll go with lewd, and we will go with harassing, and we will go with pornographic. And the problem is I could probably go to everyone on this council and ask, what is your definition of lewd? What is your definition of harassing? What is your definition of pornographic? And I would get probably some similarities, but also a lot of differences. And that's the problem that content moderators face every single day. We were asking about content moderation writ large. And since Mr. Halbert promised I would talk about it, I will talk about it. Let's use an example. Something that was recently banned, or unintentionally. So Google or Facebook or Twitter or basically any platform, Bing, whatever, says no child nudity. No images of child nudity shall be shown. As a parent, I'm like, great idea. Let's do that. Great, let's do it. Well, what ended up getting wrapped up into that? The famous image from Vietnam of the naked little child running from the napalm. Historical image. Oh, well, that image of child nudity is okay because it's a historical event. It's very important. It was, on the cover of Time and similar. So you see how we can't even just have a blanket statement for no child nudity. Okay, how about this? Search engine optimization, right? So let's presume we have no categorization or editing of searches. So you type in the words, you get whatever is a site that uses it the most. And this was something that Google had to deal with early on. So it was Holocaust denial. So if you did a search for Holocaust did not happen, the most prominent and almost all of the results you would get for the first couple of pages are Holocaust denial sites. Because what ends up happening? The only ones talking about Holocaust denial are the ones who didn't think it happened. Same thing for moon landing, right? Moon landing didn't happen. All of the search results, unfiltered, were how the moon landing didn't happen. Because the only ones people talking about how the moon landing didn't happen are people who believe that. So they realized, oh wait, that's not necessarily what people are searching for or similar. Okay, so let's jump into some of the legal points. And I did want to dispel some of the confusion and questions surrounding. So as I was driving in here in my taxi from the airport, we drove past a sign just across the street. It reads 1996. And of course, 1996 was not referencing to the Communications Decency Act. It was referencing the Olympics that were here in Atlanta. And a lot of us remember that and feels like just yesterday. So 1996 actually isn't as long ago as I like to believe. I'm often reminded by my child, he thinks I'm old. But aside from 230, Section 230, there's a different 230 that I think is more important, and it's 230 years ago when the Constitution was enacted. And there are 45 words in there, which constitute the First Amendment. And I stand by the First Amendment. I'm an originalist. I hold it in such high echelon. As much as I don't like Nazis, I believe in their right to march, right? So that's where I land. And that's why I really start to worry when I hear any idea of government telling a business what it can and cannot say. Now, we did hear examples of kicking people out of a restaurant for the color of their skin or their religion. Now, the thing is, regardless of that, if you go in there and you're naked or you're wearing an offensive shirt, they can kick you out. If a social media platform or any business does that for race or religion, they can kick you out. But those are what are called protected classes. When it comes to political speech, this country has never considered political speech to be a protected class. Let me give you an example. Let's presume that somebody doesn't want to have any political speech at their business. I think that's a fair statement. If you're a business operator today, everybody's so heated about politics. We're heated about politics all the time. I don't want my employees bickering. I want them doing their jobs, right? So I'm just going to pass a rule: no political speech in the office place. Well, if suddenly political speech is a protected class, you can't do that. Let's use the example of the online store or the offline store. Imagine going into the mall, and the mall has a policy that says, no, I don't want to have the neo-Nazi store in the mall. That Nazis are a political class. We typically don't think of them that way, but they are. Unfortunately, there is a Nazi political party. So we would have to recognize all their rights, all their ability to say whatever they want all the time. There's a group called NAMBLA, National Association of Man Boy Love Association, right? Child predation. We would have to recognize their rights to say whatever and do whatever they want. So it's very difficult. I know we often think of only Democrats and Republicans, but political speech is incredibly broad. So there's real danger there. Looking at the First Amendment in and of itself, the decision that we got out of the Florida court said, like prior First Amendment restrictions, there's an intense burning of the house to roast a pig. And that's oftentimes the problem that we're going to see with almost any law that the government tries to pass. It's really hard, as I used with my example of lewd or harassing or even child pornography, to really zero in on what the exact content is and define it so precisely. We want to allow Democratic and Republican speech, but we don't allow Nazis. Maybe we want to allow the Communist Party, maybe we don't. So it's very hard to get into that precision. One of the other things that was raised was on and argued previously is because these are monopolies, or as some have referred to them as cartels, and thank you, Mr. Chairman, for recognizing that they're not entitled to free speech. Well, to put some more color, to give you a couple more examples of sites that compete directly with Facebook, we have LinkedIn, Reddit, which I use a lot. TikTok is taking away so many eyeballs, because that's the other thing. You can be on both sites. I think my mother-in-law asked me, why haven't you liked my Facebook post? And I'll say, because I haven't used your Facebook in like a month. So but I'm still a user, right? So they're not mutually exclusive. But even if they were a monopoly, let's assume for the sake of argument that they are, monopolies are entitled to First Amendment speech and First Amendment protection. In a case went all the way up to Supreme Court, unanimous decision, Berger Court said in Miami Herald versus Tornillo, Miami Herald, one of the factors was that they were basically the only newspaper at the time in the area. They had a monopoly on the area. Court didn't pay that in any mind and recognized that the state cannot force them to host political speech that they didn't want to publish. Similar case in PragerU versus YouTube, so a bit more 21st century here.
And Mr. Zaba, if you could kind of take 2-3 minutes to kind of wrap up.
Yes, sir.
Appreciate your presentation.
Court out there said, despite YouTube's ubiquity and its role as a public facing platform, it remains a private platform, not a public platform. So the other argument is, well, what about public areas? Facebook, YouTube, Twitter argue that they are public fora. Some have argued that they are public fora and therefore not entitled to any First Amendment protections. The first question is, how do we define public fora? So for that, I will turn to Justice Clarence Thomas in 1992 in a case called Krishna Consciousness, where he said, property that the state has opened for the expressive activities by part or all of the public. So created by the state. And in that case, it was whether an airport was considered to be a public fora. And the Supreme Court said no. So ATL, right around the corner, I was there a couple hours ago, certainly got a lot more federal funding than Facebook, Google, or YouTube, or Twitter, or MeWe, or Parler. Not a public fora. What about the temple? So I was in Atlanta a couple years ago at the synagogue called the Temple for a wedding. Synagogues, churches, they say we're open to everyone. We will take your poor, your weak, your impoverished, open to everyone. If somebody walks in, can we not kick them out for violating decora, for going in and flipping over tables or turning over church pews? They claim to be open to everyone, but of course not. What about a library? Library, very close to a public fora. Should a library be required by law to carry copies of Mein Kampf or the Anarchist's Cookbook? No, maybe on the first you can make an argument, certainly not on the latter. So that's part of the challenge that we're facing is they are not public fora, and therefore they're protected by the First Amendment. So I'm just going to close per your request, sir. I really do appreciate your opening, Mr. Chairman, where you said you need to, you're worried about acting first, then debating later. Many other states, or at least one, has decided to act first, litigate later, and we hope you do not head down that road either. But at the end of the day, you have legis.ga.gov. If we want to create the true public square where the First Amendment basically protects any content removal, everything up to the extent of the First Amendment, we can create townhall.ga.gov, right? And it will be fully protected by the First Amendment, not private, government created, but you will have to recognize that there will be things that are protected by the First Amendment, like child grooming, bullying, election disinformation, pornography, beheading videos, animal cruelty, pictures of children at a park. Imagine doxing. I was a victim of doxing the other day. So fortunately, the First Amendment allowed that platform to remove it. People posted my home address, and that was very scary. And they suggested that people do harm to me. And if you want that type of fora, you can test it out today. You can go to 8chan or 4chan, where they basically enshrine no content moderation, and they do that. But it is the First Amendment, and then Section 230 is merely a litigation tool that protects small platforms from being sued into oblivion. And the CEO of Parler had actually said that he needs Section 230 to make sure that he can continue operating where they also do engage in a certain level of content moderation. Thank you, and I welcome your questions, please.
We are really out of time. If members want to stay after and ask questions, people will be available to do that. We're not done. We've got more speakers. I've got 2 more to go. I want to be respectful, given an hour and 20 minutes to kind of hey, is it fair to characterize your perspective as being, hey, really, this issue is not right for state action. You'd prefer the state not to act in any way, and let this be managed at the federal level. Is that a fair characterization of your perspective?
You know, I think President Reagan said it best when the 9 scariest words are from the government. I'm paraphrasing, and I'm here to help. So I think in this case, the market is acting absolutely appropriately. You are seeing new entrants to the market to address demand from users. Rumble is a great example of that, where they now have at least a $500 million valuation and millions of users. Donald Trump launched America's First on Rumble, and that is now filling a demand that people are not seeing on other platforms. So I say, as an originalist, First Amendment holds true. And I'm saying as a conservative that we should allow the free market to do its job as it is today.
Mr. Zybro, great presentation. Thanks for being with us today.
Thank you very much.
Chair recognizes Mr. Alum Bakari. Welcome. If you come up and tell us who you represent. And again, members, we let Mr. Halpert go a little further. We let the questions go on a little longer. I think it was helpful and instructive to our perspective. We may hear a different perspective from Mr. Bakari, but appreciate you coming here and joining us today. Again, these speakers all came from out of town. We do have one academic that's going to beam in remotely here later before we wrap. But Mr. Bakari, you've got the floor. Thank you.
Thank you. I appreciate the invitation. This is the first one of these things I've done. I've been covering technology for 5 years now at Breitbart News, which I readily admit I write from a partisan perspective. I think it's preferable for journalists to admit their partisan bias rather than trying to conceal it, as many do. But I'm going to try and keep this brief. I had a whole 20-minute speech prepared, but I'm going to spend.
No, Mr. Bakari, you got your 20 minutes. I mean, again, I don't like to be so crass in committees to say sides, but there is a perspective of, hey, this is really not right for the state to act. That was largely
Yes.
Mr. Zaba and Mr. Alpert's perspective.
Yes, indeed. Well, I also want to correct.
I'm not going to rush you along. I'm going to let you be questioned significantly by the members of the committee. So take your time,
Yes.
make your presentation, and committee members will have an opportunity to question Mr. Bakari extensively.
Thank you. And I do want to respond to some of what's been said. There's quite a lot to respond to. There was a lot of talk about family friendliness and keeping the need for social media platforms to keep themselves family friendly. An interesting thing about how Google and Twitter and other platforms deal with obscenity is that it's opt out. So if you go on Google and you want to have a family friendly experience, you click a little button in the top right hand corner called Safe Search. And when you turn that on, obscene results are filtered out, but you can choose to turn that off and see the obscene results. Twitter has a similar feature called Sensitive Search. And when you turn the Sensitive Search filter on, it will filter out images of extreme violence, obscenity, and so forth. So it's interesting to me that tech companies have this technology for voluntary content moderation that you can opt in or out to. But they only apply it to obscenity. They don't apply it to other types of content that they moderate, like so-called disinformation, much vaguer terms of content, actually, like disinformation and so-called hate speech. We've also heard, pretty extreme examples, people going into to challenge the public accommodation argument, such as, a customer who goes into a store and takes his clothes off, or someone who's in a bar and starts screaming. But many of the examples we see of people being deplatformed on social media and losing access to their accounts and their businesses are not at all examples like that. They're examples of people who simply go on and post certain perspectives, like your constituent. So I don't think that's comparable. So I think the non-partisan question here is is the question of user choice. So in when lawmakers wrote Section 230 in 1996, they took the step of declaring their intentions in the preamble of the statute. So they wrote that the purpose of the law is to encourage the development, and I'm quoting from the statute here, to encourage the development of technologies which maximize user control over what information is received by individuals, families, and schools, and also to remove disincentives for the development and utilization of blocking and filtering technologies that empower parents to restrict their children's access to objectionable or inappropriate online material. So they're talking about, that language is talking about giving powers to the user and giving powers to parents. It's not talking about giving power to Mark Zuckerberg and Jack Dorsey. And I think that gets to the heart of the issue, because I think this whole debate has been unfairly presented as, more content moderation versus less content moderation, when the real question is, I think that's kind of a false dichotomy, because the real question is who gets control over the content moderation. So in the case of Google Safe Search, users have control over that. But in many other types of content that is now regulated by the tech platforms, users don't have that control. And I think, a question for lawmakers is why is that? Clearly, if the trend over the past 5 years, I think, hasn't been to maximize user control over information, as Section 230 says, but to minimize it. So I think the question that needs to be asked here is, why are users allowed to opt out of filters on obscenity, but they're not allowed to opt out of filters on certain types of political expression? If the tech companies already have systems in place for voluntary content moderation that you opt into, why isn't that the standard? That seems to be the clear and obvious route to achieve what Section 230 set out to do, which is to quote unquote maximize user control over information. But tech companies have decided to go in the opposite direction over the past 4 years. They've chosen to minimize user choice rather than maximize it. And I don't think maximizing user choice should be a partisan issue. It wasn't a partisan issue in the 1990s when Congress passed Section 230, but it is a partisan issue today. And it's become a partisan issue, I think. And this also responds to another point, which is that the tech companies are just trying to satisfy users, that they don't want their users to leave. There are actually a lot of other incentives that tech companies respond to, especially over the past 5 years. We've seen extremely powerful interests, both national and international, that want to skew the digital marketplace in their favor for commercial and political reasons. One big example of that is media companies, big media companies, international media companies, including News Corp, by the way, that want tech companies to give them an advantage over their competitors, and they whip up negative press coverage against the tech companies until they get what they want. So that's another big incentive that tech companies respond to. It's not just what their users want. They have to pay attention to what the media wants as well, because the media is capable of whipping up enormous advertiser boycotts that can cost these companies hundreds of millions of dollars, and that has actually happened in the past. So sometimes, increasingly over the past 5 years, we've seen tech companies respond to the demands of media companies to the detriment of user choice, because they're afraid of the consequences of that negative coverage. To put it another way, if lawmakers take a laissez-faire, hands-off approach to creating standards around content moderation, then you've effectively created a power vacuum. You've left the door open for other interests in society that also wield power over the tech companies to force them to skew content moderation policies in their favor and to erode user choice. And that is exactly what's happening right now. The other issue, which I think has been addressed here as well, which I'll talk about, is the question of fair business practices. And I think that's also a nonpartisan issue. So many of the tech companies that are engaged in unregulated content moderation today have existed for over a decade now. And what that means is many of the people on those platforms have spent over a decade building up their presence on those platforms. And, you know, for some online businesses and content creators, you know, as we've heard, particularly businesses started by millennials, their entire livelihood depends on access to social media platforms. And that's also a mutually beneficial relationship for the tech companies, because the way tech companies raise money is by pointing to their monthly active users. So generally speaking, the more monthly active users a tech platform has, the more money they're able to raise from investors. So tech companies reap the rewards of people using their platforms to build their followings, engage users, and conduct businesses, but they also hold out the right to take that away from users whenever they want to, whenever it's inconvenient, or whenever a media company that they're afraid of complains about it. And yet, despite the fact that in some cases people's entire livelihood can depend on access to a social media platform, small business owners, publishers, and independent content creators currently have essentially no recourse under the law if a content moderator decides to ban them. So you've got people who have spent entire years of their lives pouring effort and resources into and sometimes financial capital into building a presence online, and yet they have no recourse if a big tech company decides to take that all away, even though those tech companies derive financial benefit from their presence on that platform. And I'm going to try and keep it brief. First, and I want to get into the questions of the First Amendment, some of the legal questions. And I'll start by saying I actually agree with the opinions on the Florida law. I actually wrote at the time, while it was being drafted, that Florida legislators were not following some of the recommendations that have been made around common carrier and public accommodation law, and that's probably why it got struck down in court. And I'll preface this by saying, you know, I'm not a legal expert. I don't have the extensive legal career that some of the people here have. But someone who is a legal expert is U.S. Supreme Court Justice Clarence Thomas. And this is the first one of these things I've done. If I'd known I could print things out and distribute them, I would have printed out the concurring opinion he recently issued earlier this year in the case Biden versus Knight First Amendment Institute. This was an opinion he issued April 5th, if people want to go and look it up. And this dealt with the right of the president to block people on social media. I would strongly recommend reading it in full, but I'll quote the most relevant section from what Clarence Thomas wrote. And this was earlier this year, so it's very much about this issue. Here's his quote. Internet platforms, of course, have their own First Amendment interests, but regulations that might affect speech are valid if they would have been permissible at the time of the founding. The long history in this country and in England of restricting the exclusion right of common carriers and places of public accommodation may save similar regulations today from triggering heightened scrutiny, especially, and this is a particularly important part, especially where a restriction would not prohibit the company from speaking or force the company to endorse the speech. There is a fair argument that some digital platforms are sufficiently akin to common carriers or places of public accommodation to be regulated in this manner. And it's important, I think, that he made the distinction between carrying content, endorsing content, and publishing content, because tech companies do all three of those things. They carry content from their users that they don't endorse. They publish their own official information through official channels, and occasionally they'll verify certain users and promote certain posts, which would suggest they do endorse certain types of content. So the question is, perhaps the speech that they carry should be regulated in a different way to the speech that they publish. And also another case that Clarence Thomas cited in his opinion was the 1994 case Turner versus FCC, which found that cable companies do not have the right to refuse service to licensed cable TV stations. And in that case, the Supreme Court ruled that, quote, the First Amendment's command that the government not impede the freedom of speech does not disable the government from taking steps to ensure that private interests not restrict, through physical control of a critical pathway of communication, the free flow of information and ideas. I think it's pretty clear from what the Supreme Court has said, what the Supreme Court is saying, what Clarence Thomas is saying, that it's perfectly possible to craft laws. It is a complicated issue, but it's still perfectly possible to craft laws to govern content moderation. Thomas suggests common carrier type or public accommodation type legislation. I think it's perfectly possible for lawmakers to impose some form of common standards on what I think is currently a wild west of content moderation, in which users and content moderators are at the mercy of powerful interests in the private sector. And I'd hope that both Democrats and Republicans can agree that both users and content creators ought to be protected, and they shouldn't simply be left at the mercy of big tech companies and the powerful interests that influence them.
Okay. Mr. Bakari, anything else in your presentation? We're going to open up for questions here momentarily. Are there any points you'd like to make? Or as you've presented your information, would you want to wrap up before we take questions?
Yeah, just to reiterate that I think while there are plenty of examples of political bias from the tech companies, I think the real concerns are non-partisan. They're about how much choice should users have and what rights should users have in relation to these platforms, and also what rights should a small business have if they depend on Facebook or on YouTube or on any one of these platforms, because currently they have almost no rights.
Chair recognizes Representative McLeod for a question.
I want to first make a statement regarding, thank you, Mr. Chairman, to the chairman. This is the second time that we've been in this meeting where you compare what went on with African Americans and Black people in this country to what's going on with the platform, and an objection to the content of a platform. Black people were property and had no liberty. And so,
and to be fair, appreciate the latest question. I would say that a Georgian, a native Georgian, Clarence Thomas, a man of color, was the one who raised that direct point in the case that Mr. Bakari references. Supreme Court Justice Clarence Thomas raised this issue of public accommodations and access in this context directly in a U.S. Supreme Court ruling. And I think it's important that context be understood as well.
Well, I disagree with Judge Clarence Thompson. Let me say that. Thomas, sorry. I do want to ask you a direct question. So you said that filtering using opt-in and opt-out, it still doesn't solve the problem of someone who's plotting an insurrection. So I'm not sure how that's going to be handled. And so for me,
I believe plotting an insurrection is illegal, and even Section 230 doesn't protect illegal content.
But that's the whole point of whenever we see, that's why law enforcement got involved and health officials got involved with social media, because those contents are online. And even if we opt in or opt out, those contents can still be, so there still needs to be clear guidelines on what can be said on those social media platforms.
Well, to clarify, when I talk about opt-ins and opt-outs, I'm talking about content that is legal, that is constitutionally protected, not incitement to violence and incitement to insurrection, which is not constitutionally protected.
The other thing I want to ask you is it only conservatives that are being removed? Because I know several people that are Democrats that were removed from social media platforms.
No, I think the bias of Silicon Valley certainly leans in that direction, but there are still many examples of Democrats, independents, and people, and even people who are non-political who have been removed. So this is really this is why I say it's a non-partisan issue, because it affects content moderation affects everyone who uses these platforms, which is today almost everyone who's engaged in the online sphere in some manner, and increasingly businesses need to be engaged in the online sphere. So it's not Democrats or Republicans. It's everyone today will probably have to rely on these platforms at some point. So for them to simply be able to exclude people without any recourse just affects everyone regardless of their political background.
But the thing is, we're sitting here because of conservatives bringing us here together, right?
Well, I think conservatives have taken up this issue because they have been the targets of bias, but that doesn't necessarily mean it doesn't affect everyone as well. So that might be the motivation, but that doesn't preclude the fact that everyone is affected by the content moderation of these tech platforms, and nobody has any recourse if they're kicked off a tech platform, regardless of their political viewpoints.
I don't believe it's our state level responsibility. Thank you.
Chair recognizes number 7. Is that Representative Davis? Representative Davis.
Thank you so much for coming. A lot of times before I even come in this door, on the grounds here at the Capitol, I say a silent prayer that we have the judgment of Solomon. When it comes to computers, I'm gonna be straight up with you. I was born and raised when there were no computers. And it was just here shortly that I was working on my phone and on my computer, and my brother's grandchild looked at me and said, "Hey, V, I'm gonna have to help you." My brother's grandchild is 6 years old. Can you imagine? And now we're being asked to regulate and write legislation. That's why I say that we need the judgment of Solomon, because I feel like we're having to balance two sides: life, liberty, and the pursuit of happiness under the Constitution. And then we have to protect against crime and criminal activity. I read one of your articles, and it was titled, "Who is in Control? The Need to Rein in Big Tech," dated January 2021. And the quote that I found interesting was, you said the most important demand we can make of lawmakers and regulators is that big tech be forbidden from activating these filters without our knowledge and consent. They should be prohibited from doing this, or even from nudging us to turn on a filter under the penalty of losing the Section 230 immunity as publishers of third party. Can you explain to me a little more in depth on that? Because I mean, how can we operate an online business without them having the right to use these algorithms and filters?
Yeah, and that's a very complicated question. The reason I reference consent in that article is because the tech companies have the technology to allow users to opt out of all of these filters and all of these algorithms. That's what they do in the case of obscenity. That's what Google does with its safe search option. But for a variety of reasons, none of which I think are in the interests of users or consumers, over the past 5 years, they've created new filters on new types of content that are ever expanding, and you have no opt-out of that. So it would be as simple as simply adding a button that users can turn on or off, and the tech companies are consciously choosing not to do that.
Now, I'm a critical care nurse, and often when people go into hospitals, we give them a document. We say, read this document, and it's informed consent. The average person don't read it. Online, when they tell you to read your privacy, let's be real. We don't read it. We just hit that button, right? You was talking about the finances of the big tech companies, and I looked at the lawsuit from Florida, from NetChoice, and they also had in there CCIA, and I had to look up CCIA and found out that it was Computer and Communications Industry Association, that's CCIAnet.org, and it encompasses I mean, goodness, you have the equipment manufacturers, the communication companies, software developers, service providers, financial services companies. That sort of threw me off. Together, it said that they employ almost 1 million workers and generate more than 540 billion in annual revenue. I was thrown away. So I took that CCIA and put it in my computer to see if I ever received any information dealing with computers and communication, and I have not. How is it that we as lawmakers can be educated and receive more information on either side where we can do better legislation or hinder bad legislation? Because, I mean, without a doubt, you have the work, you have the expertise, and you have the money. I'm trying to figure out why we're not getting the information we really need.
Well, one of the big problems there with policymaking is that the tech companies have simply flooded Washington, D.C. and state houses with lobbyists, and they fund think tanks as well to craft policy behind a veneer of neutrality. And this really confuses the territory and leads to bad legislation or leads to good legislation being blocked. Like I have been covering this topic for 5 years, so I have encountered some experts who are not being paid off by the tech giants. One of whom I'd strongly recommend talking to and inviting to future sessions is Professor Adam Kandeub. That's Candeub. He's a professor at the University of Michigan State, and he also worked on Section 230 reform in the Trump administration. That was cut short by President Trump losing the election, of course. The other two people I think who know this area better than almost anyone would be the FCC commissioners, Brendan Carr and Nathan Symington. I'd strongly recommend talking to them. They have enormous amounts of expertise in this area. So it's certainly possible to find experts on this topic, but it's also quite difficult because many of the experts at think tanks and at academic institutions are being funded by the tech companies to produce the arguments that they want to be advanced in the public sphere.
And I tell you the truth, I watched videos on all of you. It was quite entertaining. And probably when I go back, I'm gonna watch some more. I learned a lot, had me Googling a lot of you have a lot of acronyms and so forth that I have to look up. How do you have to try, and as a nurse, we have our own dialect. So I have to put it in a layman's term. When it comes to computers, y'all have your own dialect that you need to try and put it in a layman's term where we can understand. I'm looking at this issue of the First Amendment. The last time we had a meeting, they talked about the public square. At one time, it was permissible to lynch people in the public square. They took pictures and they sent it out to family and friends. But during that time, the people they were lynching looked like me, and they were devalued. When you let people put on the internet the rape of children, it devalues those children. How do we balance? Because I'm talking about the judgment of Solomon. How do we balance this issue on the scales of justice so that righteousness and what is right, yes, prevail, but so does life, liberty, and the pursuit of happiness? Because right now, I feel like on both sides, y'all ready to divide the baby.
Yeah, I think it's extremely important that we draw a distinction between like illegal content and legal content, and be very clear in the distinction between regulating those two types of things. And I think tech companies should face the maximum penalties, probably much bigger penalties than they currently face for hosting illegal content of that nature. And I think one of the problems with getting tech companies to, obey standardized rules is that they're so wealthy that in many cases, even hundreds of millions of dollars in fines doesn't affect them, and they just brush it off. So it's generally, it's very difficult to impose any kind of standards on the tech companies one way or the other.
Well, I want to thank you and know that I did not get to watch about 2 of your videos. I'm gonna go back and watch them. And I thank you for making me take the time to look at this issue from a different perspective. You challenged me to do that, all of you did. And I want to apologize to my chairman. I don't know if I acknowledged you before I started speaking, but I want to thank you for bringing these speakers because it challenges us all to see different points of view.
Thank you for the questions.
Thank you, Representative Davis. Appreciate you. Chair recognizes Representative Gilligan.
Thank you, Mr. Chairman. And just one brief comment and then a question, if that's okay. So my brief comment is I appreciate everybody who came in and spoke to us and all the great questions that I've heard from my colleagues here. My question is.
And we are going to have one more speaker that's going to beam in when we're done with questions here.
Oh, okay.
As we did before, we had a longer presentation and questions, and then we'll have here we had presentation and questions. We'll have a last speaker that's an academic from the University of Chicago. So, don't be packing up your bags just yet. We've got a little bit more to go. So you got the floor.
Okay. Thank you again. So my question is really centered around how do I, in my position, protect Georgia citizens and our ability to get our words out and to be heard. I had already highlighted in the 230 what you had brought up here about user control, parental control, empowering the parents. And so is it possible for us to look at legislation that protects Georgians and our ability to have more user-defined content control as opposed to what another state may do? In other words, we know that other states protect citizens' data better than Georgia does. By the way, we still have that in place in Georgia. California has better protections than we do. So does that mean that Georgia could have better protections, allow more user-defined control as opposed to large tech company control?
Again, I'll preface by saying I'm not a legal expert, but I think based on on the stories I've covered over the past 5 years, it's perfectly possible to do quite a lot at the state level. And, Clarence Thomas makes that clear as well. And one of the things which also made it clear was what the Democrats did in 2017 and 2018 when Title II common carrier restrictions were repealed at the federal level. They then went to the state level and reimposed them there. So you can actually impose common carrier regulations on businesses at the state level, and you can also impose public accommodation regulations on businesses at the state level. So there is a lot you can do. There's always the danger of a federal law like Section 230 superseding it, and then it becomes a federal issue, not a state issue. But certainly with the net neutrality debate, Democrats show it's quite possible to do a lot at the state level when it comes to common carrier and public accommodation type laws.
Well, again, thank you very much, and I look forward to the next speaker.
Chair recognizes the minority whip, Representative Wilkerson.
Thank you, Mr. Chairman. I guess I have a question. I did get a chance to do a little reading over the last few days as well, and I got a chance to look at your book. In that book, I was trying to find, it always helps me to find out who's doing it right. Because apparently from reading the book, it looks like Wikipedia, YouTube, Facebook, et cetera, are all doing it wrong. They're all wrong and they're harming people, even though Georgia is a pro-business state. And typically business is a lot more nimble than the government. So I always get curious when I see that you want us to regulate industry when there may be a threat. And I think the earlier person spoke about bad actors are always ahead of us. So it's hard for the law to keep ahead of us. So law enforcement goes to them and works with them. So two questions, I guess, are one, who's actually doing it right? Like what tech company, or are they all wrong? Are they all biased and the whole world is against you? And then two, what content would you actually consider to be threatening? Because just because it's lawful doesn't mean it's not awful, as they said earlier. And so do we have to hold ourselves a higher standard than just what the basic law says? Or is the law the threshold, the floor, and we should always expect to achieve higher than that? I mean, just like, you go to church and there's certain things that, are sins, but there are other things that you have to hold yourself to a higher standard. Do we as legislators want to hold ourselves to the lowest possible standard? Or do we want to encourage people to be good corporate partners? So those are my questions.
Yeah, those are great questions. And I'll address the last one first. I'm certainly not going to say all legal speech on the internet is great and good, and we should all support it, because obviously there's some crazy and terrible stuff on the internet that's legal. And I think the issue is people. Well, there are two issues. First of all, people have different levels of tolerance and are, interested in different types of information at different times, and, their views of what's objectionable changes. So that's why it's important, I think, to give users the maximum amount of choice over what they see, so they can decide what they consider is objectionable, and they can decide what to filter out and what they do want to see and what they don't want to see. And I actually think you mentioned, what tech companies are doing it right. I actually think the Google Safe Search model is a really good model for content moderation, because it does filter out a lot of the awful stuff, and it still keeps control in the hands of users. And it just baffles me that they use that kind of technology for obscenity, but their filters on so-called disinformation and so-called non-authoritative information, you can't opt out of them. I don't think they've ever justified the disparity in the standards that they use there. So yeah, no, certainly we don't want to, I'm not going to endorse every post that's ever been made on 4chan, but I think it's good that people have access to a wide amount of information and a wide amount of content moderation tools and filtering tools, so that they can control the kind of experience they have online.
Okay, so final follow-up question. So you are saying that there are other options out there. So if I start a business, and I think the earlier person did speak, that if we have very specifics, because as legislators, we get calls all the time. And what we try to dig is not just the first level, but what is your actual problem? And I think they said they'd be willing to look into an actual problem, because to this date, we've had 2 hearings and I haven't been given specific examples of what the person actually did that led up to them. It's like your kid comes home and complains about the teacher did something to them, but they didn't talk about the first 30 minutes when they were picking on somebody. They just talk about the last 2 minutes where they said something. So I would be curious to see if we can get the actual details and work with the gentleman that had offered to work with us on crafting that situation. I always hesitate to change law based on the situation unless we get all the details and make sure it's a systemic issue and not a situational issue. But thank you for being here today, and I appreciate the feedback from everybody we received, and thank you, Mr. Chairman.
Thank you. That's the end of our questions. I'll again, I try to hold mine, let the committee speak first. I will ask a question to you. Are there examples, you talk about non-authoritative information. I know this discussion's all sort of centered around what's happened in our recent history. Everyone thinks this is all about politics. It really is bigger than that. Are there examples of otherwise legitimate religious content being filtered? I mean, you think about sermons and things being pulled off. There are people that have vastly different opinions on theology and on beliefs of the eternal. I've seen examples where churches and pastors have said, "Why did they take me off YouTube? Why was that deplatformed there?" Could you share some examples, or do you have any offhand, where religious content that would be otherwise legitimate has been not had the opportunity to get through a filter, but it's been deplatformed, that speaks to not just politics, but also a protected class, which is one's faith?
Well, actually, some of the leaks from the tech companies have shed some light on this, and one of the reasons why I've been able to, report on the tech companies, because there are many very courageous whistleblowers inside Google and Facebook and Twitter who blow the whistle on what they see as wrongdoing inside those companies, and have allowed us to understand a little more about how these, very, very secretive content moderation mechanisms work, because, they're not subject to actual, legal transparency requirements. And two examples that spring to mind are, one was a leaked video of a Twitter employee published by Project Veritas, in which he is describing how Twitter categorizes bot-like behavior. And he says that, on camera, he says that accounts that just tweet about God, guns, and religion. I'm paraphrasing a little bit there, but that certainly religion was a part of it. They're quite likely to categorize those types of accounts as bots. Another example that springs to mind is, and this came from a leaked document that I published at Breitbart News, is YouTube's search blacklists. And blacklist is not my word. That's what that's how YouTube describe it. They have a file that they use inside a company, inside the company, that they call a search blacklist. And when they add terms to that list, it reorders search results to favor YouTube's hand-picked verified sources. And some of the terms that they added to those to that list to manually reorder search results was the search term abortion, and numerous search terms related to the referendum on abortion in Ireland that took place in 2018. So that's obviously both political and a religious topic, but the result of that intervention was that numerous videos from a religious perspective fell out of the top 10 search results for that topic. So, regardless of your views on that particular issue, that's a clear example of YouTube using its power to affect a political topic, affect a religious topic, and in the case of the Irish referendum, even affect a democratic vote.
So I asked the question because this is, we do well to step back and pan back and not just be so focused on the last couple of months. This is a broader question. And we do have another speaker I'm going to recognize, but I do see concerns about, with no transparency, no ability to change filters, that literally an entire category of ideas, an entire category of religious expression is unilaterally controlled by an entity that controls 80 to 90% of all search. That is a substantive thing that addresses a specific enumerated right that we have a direct responsibility and obligation as a state to handle. And if we say it's okay, we can deliberate about this. And but I would agree with my friend Representative Davis. We do need the wisdom of Solomon in deliberating about these very important issues. So I appreciate your time, Mr. Bakari.
Thank you.
And with that, the chair is going to ask our staff assistant to recognize Dr. Luigi Zingales from the University of Chicago School of Business. He's going to make a remote presentation. He could not be with us physically today, but we treasure his involvement in this, and is going to speak to this issue from his own perspective. And with that, I'd like to recognize Professor Zingales. Welcome.
Thank you very much. Thank you, Chair Salter. Thank you, members of the committee. Thank you for inviting me to discuss these important issues. First of all, I want to acknowledge that neither I nor the Center I direct, the Stigler Center, receive any funding from big tech. So with this, I would like to start framing the problem. So in the last 20 years, we have seen an enormous growth of technology in our lives. And by and large, this has been a gigantic benefit. We have at our fingertips more computing power than was used to send the man on the moon, more information that is contained in the best library, and more power to communicate than any propaganda machine ever dreamed of possessing. And for the average individual, this would not be possible without the proper applications. And companies like Apple, Google, Facebook, Twitter, Amazon, what we and the press calls big tech, this will not be possible, and big tech will not have improved our life. So the question is not, did big tech make our life better? Because the answer is, of course, yes. The real question is, can public policy make big tech even better and more useful to our life than it is today, and how? So let me first clarify some facts that are often in dispute, but I think that I would say pretty confidently that 90% of the economists will agree with both of them. The first one is, while we consider digital platform service free, they're not free. Okay, if I go to a restaurant and I end up paying for my meal, washing dishes at night in that very restaurant, I don't pay any dollar for my meal, but I do pay for my meal. I pay with my work. And that's exactly what we do with our data. We give data in exchange for services. And as I will tell you in a second, this exchange is very beneficial to the companies more than it is beneficial to the individuals. And second, we do pay indirectly. If I try to look for a house and I hire a real estate agent, most of the time I don't pay out of pocket anything. Why? Because my real estate agent is paid out of the seller proceeds. However, as every economist recognizes, in equilibrium, I do pay for that cost indirectly. And we all pay for that cost indirectly through the cost of advertising that is built in the goods we buy. The second thing is that digital platforms operate in markets that naturally tend to monopoly. So all the discussion we do about free enterprise system, etc., needs to be qualified with the fact that this is not your average grocery store at the corner. This is not your average enterprise. It's an enterprise that operates in market that, because of what we economists call network externality, naturally tends to become monopolists, and they're subject to what is called as tipping, that once somebody becomes big, it's very difficult to undo that. And so they naturally have bias to entry, and that historically this bias to entry has been made worse by exclusionary practices and by the fact that the FTC and the DOJ have been asleep at the wheel whenever there was a merger. So, given these facts, what is the evidence of harms? As correctly, some of representatives said, we don't want to operate without having the facts and the evidence of harm. Now, to prove the harm beyond reasonable doubt, you need to have an investigation, and some investigations are under place. However, as an economist, I can tell you that there is prima facie, which is a strange expression to say, first evidence of harm in many dimensions. The first one is economics. The very same fact that these companies are making large profits without triggering entry suggests that consumers are paying too much, or they are compensated too little for the service they receive. If I wash too many dishes in order to pay for my meal, I am paying too much. And that's exactly what the evidence seems to suggest. The second is not only an evidence in terms of prices, an evidence in terms of quality. And one dimension of quality is privacy. When Facebook was competing with MySpace, was very careful on the quality privacy dimension. Once it became the leading platform, then that attention disappeared, and now is quite the opposite, not very protective of privacy. The second term of quality is abuse of addiction. We know that people tend to spend too much time in front of the gadgets, and companies not only do nothing to prevent it, in fact, do actively work to maximize this, and that's not good. Finally, innovation. I don't think it's a coincidence that the only real important new entry, TikTok, comes from China, not from the United States. Why? Because the incumbent monopolists are not innovating enough and are preventing innovation. So that, as far as economics is concerned, let's talk about privacy. So privacy, we have massive data leaks that jeopardize our most secret values. Not only that, companies want our data, not only to sell us ads, but also to extract more surplus when they sell stuff to us. And government wants more data to us, to tax us, and to surveil us in many possible ways. And so This is an unusual situation because in normal situation, there is a tendency between the company interest and the government interest, and this tension provide a very powerful system of check and balances. In the case of data, both government and companies are in bed together. They both have an interest in getting more data from us and use it for their benefits at our expenses. This is where the role of Congress and state Congress is important in protecting people against concentrated power, whether this concentrated power takes the form of government power or of companies' power. In this case, is not much different. Then there is an important media problem. We know that big social platforms have allow out the revenue of most local newspapers. Now, this is a sad story, and this is important for the political system, but it's no different to what cars have done to buggy whips and so on and so forth. The real problem is twofold. This number one is the fact that three people are basically editing the content that billions of people in the world receive. So is the disproportionate concentration of power in the hands of three men. And second is the very business model of social media is to feed us poison to keep us engaged. So I've heard earlier one representative say that they are not in the edited business. It's not true. I think that all the social media select content and push content to keep us attracted to those very social media. And so what is the content that works the best for them? What is most provocative? What is most titillating? So they are in the business of pushing poison to keep us engaged. Last but not least, I think that the media, social media, play a very negative role on our democratic system. First of all, they contribute to the polarization by pushing this extreme content. So the fact that the conversation are so acrimonious on Twitter is by design, not by accident. And the second is these companies have a disproportionate influence on our political system. They not only they have money, they have agenda setting power, they have ability to mobilize, they portray themselves as national champion. They have all these things together, and that brings a disproportionate power. But the last and not least, even from your point of view, they have, in principle, and I'm not saying that you so far, but the threat is there, in principle, the ability to select who is going to be elected. Just the way they organize search, if I get all the bad news about me first and all the good news later, my chances of being elected to public office is really reduced, and they have this power today, and I think we should consider what to do before it's too late. Now, what are the possible remedies? I am not somebody that thinks that one size fits it all, that by breaking up everything, you're going to fix everything. I think that it's important to go case by case and trying to fix the problem with, in my view, the minimum intervention possible. So what is the biggest problem of social media that leads to monopoly is what we economists call network externalities. What is a network externality? Is a fancy word to say something very simple, is that I want to be in the same network as my kids and my friends. And so if they are on Facebook, I want to be in Facebook. If they're on WhatsApp, I want to be in WhatsApp, and so on and so forth. Now, this problem is not new. When telephones were invented, this problem started to arise. And at the time, in order to call somebody, you had to be in the same phone services that the other person. How this problem was fixed by mandating interoperability. Today, I'm not worried if I want to call my friend, if he's on an AT&T, Verizon, or T-Mobile network, not because AT&T and Verizon are nice, is because there is a rule that if I have a T-Mobile phone and I call Verizon, Verizon has to take my call and vice versa. That's called interoperability. That's something that is absolutely possible to introduce in the social media and will make very easy to have a market for content moderation. What the gentleman before me was saying, we need to allow consumer to choose content moderation. Now, it's not possible to allow them to choose content moderator when you have only one provider. However, in the moment in which you can switch around, I think that it is possible to choose your own content moderation. That's what Francis Fukuyama at Stanford suggested as a middleware and competition in middleware. But to have competition in middleware, we need to have more interoperability, because without interoperability, I think this is not possible. Now, notice, and I strongly recommend, since you are watching other video, etc., let me promote not one of my video, but one of NPR, in which there is a video by Planet Money, where they a podcast where they talk about a small company, Power Ventures, that was sued out of existence by Facebook. And this Power Venture was doing exactly what I think we'll all love to have, i.e. a company that moderate different social media for me and let me post on different social media, is doing this moderation that puts consumers in charge again. And I think that should be the first button. The second is, I have a mixed feeling about Section 230, because I think that I do recognize that if you want to let a lot of people the free to post, you can't have too strong enforcement of liability, because you're going to put out of business the small organizations. However, there is a big difference between freedom to post and exploiting posting for promotion. And I think that what many of these platforms are doing are not simply letting people post, they are using those posts to get more attention, get more eyeballs, get more money. In that case, they act as editors. And when you act as editor, you should have the liability as an editor. I think just fairness in comparison to other media like newspaper suggests that this should be the case. Now, I'm not a lawyer, but people have brought up common carrier and essential facility doctrine. And I know when you are a monopolist and you own a facility essential to other competitors, you are required to provide reasonable use of that facility, unless some aspect of it precludes share access. And that's why, because it distorts competition. Now, I think we need to extend the same idea to the market for ideas and electoral competition. Facebook, for example, is competing in the market for ideas. For example, it's trying to convince people that introducing a cryptocurrency like Libra is a good idea. That's part of its business model, but it's also part of the healthy battle for ideas. However, as Facebook, I can limit the access to my platform to people who fight against Libra or think that Libra is not a good idea for the people at large. So I am distorting the competition and market for ideas, and that distortion can be fixed. Last but not least, some people, among which Paul Romer, Nobel Prize in Economics, has suggested that we should resort to taxation. As economists, we know that every time there is a distortion in a place, and in particular, there is an externality, one way to address it is to tax it. And the ad-based business model of social media is a model that produces enormous set of externalities, from the loss of data privacy to addiction to negative political polarization. So it's only fair to think about taxation. And this is something that can be done at the local level. You tax all the ads that are viewed by people in Georgia. This has been done by Maryland, and this can be done as a measure itself or as a pressure to obtain something that maybe at the state level you cannot obtain, but you care enough so to create the pressure to do it at the federal level. Thank you.
Dr. Zingales, I appreciate that. That was a detailed run through of another whole number of items. We are about to wrap up on time today, but I think I was taking notes, and I know we had spoken a little bit before the hearing today. There's a lot of resources, a lot of issues you raised that we may need to unpack moving forward. Perhaps there's some questions I could follow up with you on with some members of the committee if they wanted to.
Absolutely.
For example, the Planet Money, the NPR piece, for example, there may be some things we want to dig into. I'll be reaching back out to you if there's and there may be some committee members that want to connect with you to get some more feedback to take a deeper dive into the many issues you raised for us today.
Happy to do it anytime.
Well, I just so appreciate your time. I know you're, as an academic, busy. When we were talking yesterday, you had folks in your office. You've been very kind with your time, and I just really appreciate your expertise and your involvement in our process here in Georgia.
My pleasure, anytime.
Thanks. So I've got 12:37. We've gone over about 7 or 8 minutes. We started a little bit late just to get everyone situated, so we're right about on our timeline. I'd like to thank everybody for being here with us today. And again, our approach is to be deliberative. Our approach is to listen, to have crosstalk, that ultimately, if we act or if we don't act, however we act, we are doing so with the wisdom of Solomon, as it was said by one of our committee members. So I appreciate your involvement today, and we stand adjourned.